way of introduction, my name is Todd Berger. I'm an associate professor of law and the director of advocacy programs at the Syracuse University College of Law in Syracuse, New York. So it's an honor to be here today to be speaking to whoever happens to be out there through the American Center in Moscow. So good morning. If it's morning where you are, good afternoon or good evening wherever you happen to be. So the topic for today's presentation is called An Introduction to the American Criminal Justice System. It's a survey of American criminal procedure from arrest through sentencing. So the idea today is to just give you sort of a basic overview of what American criminal procedure looks like and the process of an American criminal case from the point that someone is arrested, the point that someone is sentenced, and then we'll ultimately briefly address what happens after the sentencing as well. So this is just designed to give you an overview of how, from the moment of arrest through to the end of a case, a typical American criminal case may move through the American system of criminal justice. I'm going to give you kind of an overview of that process and also the rights that the defendant has and rights that the state has along the way. So hopefully at the end of this, you can be somewhat more conversant in how the American system of criminal justice works and compare it to the system of criminal justice in whatever country you happen to be in. And you can be able to sort of see how things might be very similar in different countries and things can be different as well. So to begin, wanted to point this out. In American criminal procedure, there's really two, I guess you say, types or areas of American criminal procedure. There's what we call investigative criminal procedure and adjudicative criminal procedure. So in this sense, American criminal procedure is divided into two categories. So investigative criminal procedure really deals with the investigation of crimes. So no one has been arrested yet, but maybe the police receive information that someone's committing a crime, and it deals with what the police can do in terms of investigating the crime and finding the guilty party. So it deals with everything from searches and seizures to interrogations to lineup to identification procedures can occur in lineups and in other procedures as well. It's all designed to sort of investigate the commission of crime, figure out who did it, and then arrest the person. Sometimes that area of criminal procedure is referred to as cops and robbers. Right? The second part of American criminal procedure is called adjudicative criminal procedure. And this deals with essentially the rights that a criminal defendant has once they are charged with a crime. Right? So from the moment they're charged with a crime, they have their bail set. They end up going through each stage of the American criminal justice system from sentencing through to appeal. And it's called adjudicative criminal procedure. Sometimes it's referred to in an informal sense as bail to jail. So what we're actually going to talk about here today is actually the second phase of this, the adjudicative criminal procedure phase. So although chronologically first you have to get arrested before you get to the adjudicative criminal procedure phase, conceptually, or as far as the law works, you don't really need to understand what happens in the investigative phase to be able to understand the adjudicative phase. We can study them separately. And so in a certain sense, we're working backwards, but it really shouldn't matter. Adjudicative criminal procedure can be studied in its own right and is very interesting in that regard. So moving on, what are sources of law regulating American criminal procedure, right? In other words, what sort of laws are out there that define the defendant's rights and the state's rights as a part of the criminal justice process? So one, the United States Constitution, right? So this is sort of the most important document. The United States Constitution gives defendants certain rights during the criminal procedure process, both in the investigative and adjudicative stage of that process. Is that better now? Perfect. Thank you, everybody. Great. All right. So as far as this particular phase of the criminal justice process is concerned, the United States Constitution is considered the floor, right? The way that works is basically the United States Supreme Court has said criminal defendants are entitled to these rights. And as you know, the United States is a country, but it's comprised of many different states, and each state sort of has its own authority. And the United States is really a collection of, as a country, is a collection of states that have entered into this agreement amongst themselves. And one of those agreements is to be bound by the dictates of the Constitution. So if the United States Supreme Court says this is a right that a criminal defendant is entitled to, no state in the country, right, can take that away. So we consider that the floor, right? That's the minimum right that needs to be respected across the country. So the United States Constitution, as it concerns rules of criminal procedure, it's almost like a national code of criminal procedure. Investigative criminal procedure is largely comprised of rights given to defendants in the Fourth, Fifth, and to some extent the Sixth Amendment. And adjudicative criminal procedure is governed by the Fifth, Sixth, and Eighth Amendments of the Constitution, and we'll have a much more robust discussion today about the Fifth and Sixth Amendments of in the American Constitution in the context of adjudicative criminal procedure. Secondly, state constitutions, right, can provide greater rights to a criminal defendant than the federal Constitution. So we said America is a collection of states that entered into an agreement with each other, and they all agreed to be bound by the federal Constitution. But the federal Constitution is just a floor, right? A state can't give less rights than the federal Constitution, but a state can decide to give more rights. So an example is in the state of Hawaii, right? The state constitution has been interpreted to prohibit impeachment with certain kinds of statements. In Miranda, which you may or may not be familiar with, is relatively famous, but defendants have to receive certain rights, right? You have the right to remain silent. Anything you say can and will be used against you, right? So at the federal level, right? If you give an unmirandized statement and you later testify to something different, while the statement can't be used against you in your case in chief, the government's case in chief, it can be used to impeach you. But the state of Hawaii said, well, that may be allowed under the federal Constitution, but it's not allowed here. Right? So the state constitution can give more rights. Additionally, states as well as the federal government have created statutory regulations. So they've passed their own laws, right, that have essentially, they've either codified constitutional rules, so they've written into their own laws things that the United States Supreme Court has said about the federal Constitution, or they've used their own laws, so not their own state constitutions, but just sort of the separate statutory framework where a legislature just passes a law. They've done that to say that a criminal defendant is entitled to more rights than they might get under the state or even the federal the state constitution or even the federal Constitution. And then sometimes it addresses, right, purely technical matters. You know, how many days do you have to file an appeal, or right, how many days you have to request notes of testimony from different kind of hearings. So they're not really rights as much as they are just addressing technical matters. And lastly, courts have certain supervisory powers. So usually the high court in a state, so like that state Supreme Court or the United States Supreme Court, usually what happens is that court says, look, if the state legislature or Congress has not passed a law to the contrary, then we have certain kinds of supervisory powers over other courts within our jurisdiction. Sort of the idea behind it is that, right, a legislature isn't always going to enact rules that address everything. And so courts have supervisory powers to sort of fill that space themselves. So let's say the legislature said that, didn't define how much time you had to appeal a criminal conviction. Presumably, right, the state's high court, using its own supervisory powers, could say, all right, you have 30 days or you have 45 days or whatever it happens to be, right? Just to kind of fill that gap. It's given that authority by virtue of sort of overseeing those other courts. But if the legislature gets involved and passes a law to the contrary, then the state's supervisory power, or the United States Supreme Court supervisory power in the case of the federal government, that is that's subservient, right, to what the legislature or state legislature or Congress has chosen to do. So the supervisory powers exist sort of in the absence of legislative action to the contrary. All right, so now we got some of the basics, right, of sort of the rules that regulate American criminal procedure and these two areas of American criminal procedure. So now let's take the life of a criminal case from arrest through sentencing, and then we'll add in some stuff here about appeal. And we're going to do this in 8 steps, although admittedly there are a number of different sub-steps. So maybe it's more than 8 steps, but 8 sort of general steps. Here we go. Let's get started with the adjudicatory phase. So the adjudicatory phase, like I said, largely governed by the Fifth and Sixth Amendments of the American Constitution. So here you have these amendments right here. Interestingly, the Fifth Amendment itself and the Sixth Amendment itself, they only apply in a very technical sense to federal criminal prosecutions, but over time, there's a different amendment called the 14th Amendment. And the 14th Amendment is in large part, a very complex process, but in large part, it's been interpreted now to take the Fifth and the Sixth Amendment, which only applied technically to federal criminal prosecutions, and has applied that to the states through the 14th Amendment. So when I was talking before about the federal constitution has become sort of the floor, right? The national sort of code of criminal procedure. Because people are prosecuting crimes in the United States, not just by the federal government, the US government, but by their state governments as well, right? Florida, New York, California, for example. In fact, most crimes are prosecuted in the states. It's this process of making amendments apply to the states through the 14th Amendment that has created this national code of criminal procedure that exists across the country. And this is what the Fifth and Sixth Amendments read and what they look like. And in here, I just kind of abbreviated in the Sixth Amendment because the Sixth Amendment itself provides criminal defendants with a whole host of rights. And then goes on to say, things like right to confirm witnesses and call witnesses in your defense and a public speedy trial. We'll get into all of those. And then gives you the right to counsel, have assistance for his defense, which we will talk about momentarily. All right, first step, right? Charging the defendant. So the police have done their investigation. They've arrested you, right? So now the first step in the process is getting you charged with a crime, right? So in the American criminal justice process, there are two primary ways in which a person is charged with a crime. So in other words, there's two primary systems. You can be indicted by a grand jury, or there's something called the complaint, what I would say / information process. And we'll sort of go through those. But the grand jury is interesting. I want to talk to you a little bit about that. So grand juries charge people with crimes. In most of the world, right, where there were grand juries in countries that used the common law system, right, and were influenced by the common law system as it existed in England, there were grand juries. Almost every country in the world, the grand jury has been gotten rid of. The reason is that the grand jury can easily, it's very easy for prosecutors to get indictments in front of grand juries. If the idea behind a grand jury is that you're supposed to assemble people from the community and the prosecution is supposed to present their case and people from the community are supposed to decide whether or not there's enough evidence to charge you, it's a very one-sided process that is dominated by the prosecutor, at least at the federal level in the United States. There's not a lot of opportunity for the defense to be involved. And so it becomes very easy, right? Leading to this famous statement that if the prosecutor wanted, a grand jury would indict a ham sandwich or a cheese sandwich or some kind of sandwich, right? So for the most part, most places have just gotten rid of it. Right? It doesn't seem to function very well as a screening mechanism in terms of deciding whether or not a person should be charged with a crime. But in the United States, it's been kept around. And one of the primary reasons it's been kept around is in addition to the screening function that it performs, which we'll talk about in just a minute, it can be used for investigative purposes, right? So the screening function of the grand jury, is there enough evidence to charge this person with a crime, is sometimes referred to as the grand jury as the shield. It's not really valuable as a shield, but it's quite valuable as a sword. So what happens with the grand jury is the prosecutor convenes a grand jury, and then the grand jury has the ability to issue subpoenas to review documents that are not publicly available. And these might include things like a person's business record. And prosecutors can also subpoena witnesses to provide testimony under oath. So let's say, for example, the police want to investigate a crime. The police call me up and ask me if I'll give a statement. In the United States, I could say, I'm not giving you a statement, and I can hang up on the police. Right? I have that right. But if I get a subpoena from the grand jury, that means I'm compelled. I have to go down to the grand jury and under oath, right? I have to give truthful testimony. And there's, not in every instance, we'll talk about that in a second, but as a whole, right? So you can understand how the grand jury's ability, right? Or if the police call me up and say, turn over your business records, I can say, no, I'm not going to do that. So you can understand how the grand jury is a very important investigative function through its subpoena power, right? It can compel the production of documents or compel the production of testimony that otherwise people could, in the absence of a grand jury subpoena, people could refuse. So talked about how, right, the prosecution can compel this testimony before grand juries, but that's not universal. They don't have access or the right to every single type of testimony. So in the United States, there is something called the Fifth Amendment right against self-incrimination, right? So the government can't force you to incriminate yourself. And the type of evidence that the government can't force you to turn over is what is considered to be testimonial evidence. There's a very, very complicated series of discussion about what constitutes testimonial evidence. But for the most part, right, it's evidence in which you are attempting to communicate ideas, you demonstrate expressions of ideas or information that might come from your own mind and from your own thought processes. So, right. And additionally, not only has to be testimonial, but it has to be the type of evidence that might incriminate myself. So if I'm just a witness and I haven't committed the crime and no one thinks I've committed the crime, but I'm a witness and the police call me up and say, come down and give a statement, and I don't want to be involved in it, right? I don't have to be involved in it. But if I get a subpoena from the grand jury, I have to go down there and I have to give my testimony. That's testimonial, right? I'm expressing ideas or information from my own mind, things that I've observed, right? Describing my observations. At the same time, I don't have a right against self-incrimination. It doesn't violate my right against self-incrimination because I'm just a witness. I haven't done anything, right, that's going to incriminate me. But if the police want to try and get me to confess, right, and say, well, we think you did it, right, and they send me a grand jury subpoena, I can assert my right against self-incrimination, and I don't have to testify, right? I can assert the Fifth Amendment right, and that's that. So this is really kind of what I would refer to as the sword function, as I said, of the grand jury. And it's important to recognize, right? That's why the United States keeps it around, and it is very powerful as an investigative technique. Now, the shield function of the grand jury is presumably performed like this. Once the prosecutor obtains all of this information, they present it to these citizens, and they ask the citizens whether or not they believe there's enough information to return an indictment. And the grand jury gets to decide if they think there is. And there are grand juries that operate at the federal level. There are grand juries that operate at the state level. We're trying to focus for the most part on grand juries that operate at the federal level. Essentially what they ask grand juries is there a probable cause to believe the defendant committed a crime, particular crimes? And probable cause is a unique concept in the United States, right? And so what does it mean? So as courts have said, probable cause, they don't give it like necessarily a mathematical percentage. The Supreme Court has refused to give probable cause a mathematical percentage. But generally speaking, right, we know that it is less than the standard that you need to convict a person of a crime, which is proof beyond a reasonable doubt, which we'll get to later on in the class. And it's probably less than a preponderance, right? And a preponderance of the evidence is 51%. For what it's worth, some judges have said that they think probable cause, at least to arrest people or search people, is like around 40-something%. So it's probably hovers around 50% or a little bit less. But that's what probable cause means in the American system of criminal justice. And we'll touch on this later, but in federal cases where people are charged with felonies, because there's two kind of categories of crimes in the United States, maybe three, but we'll just keep it simple. Sort of two categories of crimes in the United States. There's felonies and misdemeanors, and we'll talk about how they're defined momentarily. But the Supreme Court has said grand jury indictments are required for felonies in federal criminal prosecutions, but not for misdemeanor cases. All right, so that's kind of our grand jury process. We have a little bit more to discuss about that later, but we'll move on. And then you get to the process, this other system, right? The filing of a criminal complaint. So let's say what happens is the defendant is arrested based on a police officer's observations. A police officer observes someone on the street, right, and they've stolen a car, right? They don't have like an arrest warrant issued by a judge. They just happen to see it right there, right? Or someone comes up to the police officer and says, this person punched me in the face, right? The police officer didn't see it, right? But the police officer wants to end up arresting that person for committing that offense, right? So the police officer can do that, right, in the United States. So they would simply arrest that person. But then a whole process sort of has to be followed. Once they arrest a person, usually what happens is they draft a complaint. And the complaint's either drafted by the police officer or by a prosecutor shortly after their arrest. And the initial criminal complaint is often a brief and conclusory allegation that sets forth the basic facts. So the police officer would write, I observed so-and-so on such and such a day steal a car, right? Or people came up to me, on this day, and they said that the defendant had punched them in the face, right? And that's it. It's kind of there. So the person's arrested. We got a brief kind of complaint that's been filed, right? So this is sort of an example of it. I'm not going to go through all of this stuff, but this is a sort of publicly filed complaint in a criminal case, right? You can see it right there, right? It says complaint, right? Oops, let me go back. And this just kind of lays out basically what the defendant is alleged to have done, right? They're alleged to have willfully used force and violence upon another person, right, resulting in the infliction of bodily injury. And you can see there what is from California, what violation of the California law they are charged with. All right. Now, once you've been arrested, right, assuming this has occurred without a warrant, right, the defendant has to, this is an important part of American criminal procedure, has to be brought before what we call a neutral and detached magistrate, right? So basically like somebody who is going to be fair, right, doesn't really have any allegiance to the police or to the defendant, right? They're just able to fairly adjudicate the facts without any bias. And they have to be brought in front of that magistrate within 48 hours. And the magistrate will determine whether or not there is actually probable cause to arrest that person. So usually what happens is the magistrate just reviews this complaint, right? And they look at this complaint and they make a determination about whether or not this complaint sets out probable cause to arrest this person. And this has to happen within 48 hours. So this is key, right? You can't be arrested in the United States and then sort of held indefinitely for a really long period of time before the government does something, right? You have to basically be charged within 48 hours. You don't have to be charged with every crime you'll eventually be charged with, but you do have to be charged with a crime within 48 hours, and you do have to be brought in front of that magistrate to make a probable cause determination within 48 hours. So this case called Gerstein versus Pugh says once you're arrested, the magistrate has to make a probable cause determination. Then this other case called Riverside versus McLaughlin says that has to be done within 48 hours. Now, at this hearing, this is important. The defendant is told what charges have been filed against them, and they're read this brief description, right, which we just showed you. And the magistrate is to review the complaint and then make this probable cause determination. Now, if the magistrate believes that there is probable cause, what happens is the magistrate says that the defendant can be held in custody prior to trial, right? If the magistrate does not believe that there is probable cause, the case doesn't get thrown out. All that happens, right, is the defendant can't be held in custody, right? So they're removed, they let out of jail, they can't be held in custody, but the prosecution can still move forward with the case, right? So sort of the idea behind this probable cause hearing is before we put people in custody, and deprive them of their liberty, we want to make sure that as far as this charging is concerned, there's a basic amount of evidence that the prosecution is able to put forth to justify a restriction on this person's liberty. And we want that to happen quickly, right? We want that to happen at the federal level within 48 hours. Some states move even faster. But if you don't satisfy a probable cause standard, you can't be held, but the prosecution can presumably still decide to move forward, right? So, all right, so let's assume that there's probable cause. And what happens is the magistrate says, well, I read that complaint that you just showed there, right? And I think that there's probable cause to believe that this person committed a crime, right? Somewhere around in the 40s, right? A little bit less than 50% chance, right? What they have to do is they have to go ahead and they set your bail. And defendants have, in the United States Constitution, an Eighth Amendment right not to have excessive bail. So what happens is the court, it's obviously can get more complicated, but the court essentially thinks about two things. They think, what conditions of release can I require that this person satisfy that will ensure that the person returns to court and may also protect the community if this person leaves jail. And in deciding what those conditions are for pretrial release, the court just can't make those conditions excessive, right? In other words, they can't be imposed to a greater degree than would be necessary to ensure that the person's going to return to court and to ensure that the person, the community can be protected. So there are many different types of pretrial release in the United States. One of them is called release on your own recognizance, which essentially means you don't have to do anything. We think that you'll return to court. We don't think you're a danger to the community. We're going to release you. Just make sure you come back to court and don't commit any crimes in the meantime, right? One of the very common form of pretrial release in the United States is that the defendant is required to post a certain amount of money. The idea is that if the defendant doesn't come back to court, then they lose that money. So, if your bail is $30,000, right? The idea is the defendant doesn't want to lose $30,000. So they'll come back to court and they'll take whatever, the criminal sanction is, and they'll deal with that. Because at the end of the day, they get their money back. The purpose of bail is only to ensure that the person returns to court. It's not to punish the person. So maybe the person, for example, is looking at a brief period of incarceration. Well, the person will rather come back to court and do 10 days in jail than forfeit $30,000, right? But in terms of excessiveness, the court has to set that amount in a degree that's not excessive. So if the person's will still come back to court if you give them $10,000 bail, right? That person's not going to forfeit $10,000 bail. They're going to come back to court and they're going to do 10 days in jail before they give up $10,000. That's okay, right? And $30,000 in that case would be excessive. So courts have to kind of figure out what amount they think is needed to make the defendant come back to court and not impose an amount beyond that, right, which could be considered excessive. And then the court also has to think about there's different conditions for pretrial release. So they could say, all right, well, we're going to release you, but in order to make sure you come back to court, we're going to put you on house arrest, or we think that, you might be a danger to the community here, right? You might continue to commit other crimes. So we feel like we can prevent you from committing other crimes by putting you on house arrest, right? And in certain limited circumstances, the court can deny the defendant bail, right? For example, if the court has some pretty compelling evidence that if you get released from custody, you'll start killing the witnesses, right? Then the courts have the ability to deny a defendant bail in that particular case. And that means you can just sit in jail, right? There's no conditions for pretrial release that you can meet. You're just going to sit in jail until your trial. I don't have it here, but that's governed by the Eighth Amendment, right? All of the conditions for pretrial release are governed by the Eighth Amendment. All right. In the United States, under the Sixth Amendment, you have a right to a lawyer, but not at every stage in the criminal justice process. So at this probable cause hearing, there is no federal constitutional right to have an attorney present, right? Although some state constitutions may, in fact, give the defendant that right. Usually what happens at this stage, not every place, but usually what happens at this stage, is once you have your probable cause hearing, the court determines there's probable cause, the court imposes conditions for pretrial release. The court usually appoints an attorney to represent you thereafter. And so you don't have a right to have an attorney at that exact probable cause hearing. You don't have a right to have an attorney present when you're getting your bail set. Maybe you should, but you don't. But you do get the right to an attorney. You're almost always appointed at that stage to represent you after that. And then we'll talk later on about when you specifically do have the right to have the attorney present and representing you. Not every defendant necessarily has to have this probable cause determination made by this neutral and detached magistrate within 48 hours. And the reason is that in the United States, a defendant can be arrested on a warrant, right? So if the defendant commits a crime and it's not in front of the police, right, or, and the police can't go and arrest that person, for example, right, or someone reports the defendant for the commission of a crime, right, sometimes, but they're not around the police, right? The police can't find them. The police will oftentimes go and get an arrest warrant. And police need an arrest warrant to arrest someone in their home. So when they get an arrest warrant, they go before a judge and they sort of lay out the facts. And the judge makes the probable cause determination deciding to issue the arrest warrant, which occurs before that person is arrested. And you remember, grand juries return indictments based on probable cause. So you don't need a probable cause determination when an arrest warrant is issued or the defendant's been indicted by a grand jury, right? And the reason for that is there's already been a probable cause determination that's occurred, right? So you get arrested based on a grand jury indictment, right? Or there happens to be an arrest warrant that's been filed against you. What happens is you get arrested, you get brought before the magistrate, but we're not really doing a probable cause determination at this point. Instead, the magistrate, it's already been done. The magistrate's just going to go ahead and set your bail and then probably appoint counsel. All right. In many jurisdictions, when the defendant is charged with a misdemeanor, right, the defendant can basically, if they're not going to be, obviously if you're arrested with a misdemeanor and they want to try and put you in jail, you have to have this probable cause hearing and your bail set. But if you're charged with a misdemeanor, the defendant can be brought directly to trial. All that has to happen under this case called lem won is the prosecutor just has to charge you with the crime and make their own sworn assertion that probable cause exists. And that's for misdemeanor offenses. So that is usually defined as a crime punishable by a year or less, and a felony is a crime punishable by more than a year. So in a misdemeanor offense, we had our previous complaint, right? If the prosecution, right, all they have to do, there's no additional screening other than the prosecutor drafting that complaint and signing it and saying, I believe there's probable cause. For a misdemeanor offense, boom, you can just be brought to trial with that, right? And if they never try and put you in jail, you don't need a probable cause hearing, you don't need your bail set, right? But if they're going to try and put you in jail, then you need to have the probable cause and bail hearing. But you could be brought to trial with no additional screening, right, beyond that complaint that's been filed by the prosecution. Felonies are a little bit different. So in these complaint or information jurisdictions, right, what happens is once you get the complaint filed against you, right, the court, remember that's a brief sort of cursory statement of what happened. So the court wants to make sure that before you get to trial, this case actually, there's some evidence, right, in this case to suggest that you're guilty of the offense. So in most of these places, right, you can't be brought to trial just based on the misdemeanor or just based on the prosecution's sworn statement that it exists. That would be constitutional, but in most places where you're charged with felonies, because the crime is serious, the court wants to make sure that there's enough evidence, not the court, but the system itself, right? Once the legislature, whoever crafted these laws, wants to make sure that there's enough evidence to bring you to trial. So what happens is you get arrested, whether it's an arrest warrant, right, or the police just happen to see you right then and there. They want to put you in custody. You get your probable cause hearing, right? You get your bail set, and then the court schedules what's called a preliminary hearing. And at the preliminary hearing, you have the right to an attorney. The prosecution is there, the judge is there, and the preliminary hearing is just a miniature trial, right? And it basically is. It's a more condensed version of a trial, and we're attempting to determine whether or not there is probable cause to bring you forward to trial. Now, you could say, well, I thought once they arrested you, right, and they were trying to put you in custody and they brought you before the neutral and detached magistrate within 48 hours, that magistrate was making a probable cause determination. Why do we have a preliminary hearing that is another probable cause determination? And the reason is that the preliminary hearing is just much more adversarial. So at that initial probable cause hearing, as you remember, the defendant has no right to an attorney, but at the preliminary hearing you do, right? And so that preliminary hearing makes the same probable cause determination, but it makes it in a way that's more rigorous because the defendant is represented by counsel and the prosecution calls witnesses, and the counsel can then cross-examine those witnesses or even present evidence on their own or present arguments. So this preliminary in a complaint/information jurisdiction, this preliminary hearing is an additional screening that takes place to make sure that the cases that go to trial are strong cases. And if the judge believes probable cause exists, you can be brought forward to trial. And if the judge believes probable cause does not exist, they can dismiss the case as a whole or just parts of the case. If you are considered bound over for trial, or sometimes what we call held for court, the prosecutor then takes that initial complaint and they convert it to an information. I don't know why, because the information just looks a lot like the initial complaint, but that's the system. We'll move through what the process looks like here, but this is, this is a transcript from an actual preliminary hearing that took place in the city of Philadelphia involving a stolen car case. And basically, you can see in the question, the police officer testifies, the prosecution asks questions, the defense asks questions, and then the defense ultimately ends up making an argument. So it looks like a miniature trial. Doesn't get as involved in that, but it looks like a miniature trial. And at the end of it, the court believes that there's probable cause to hold the defendant over to court for trial. Then it gets converted to an information. This is what an information looks like I said, a lot like the original complaint. However, right, in some jurisdictions, you have to have a grand jury indictment in order for the prosecution to bring the case. So, right there, you can pursue this sort of this complaint information line of doing things, but some jurisdictions say you can't do that here. You need to actually go ahead and have a grand jury indictment, right? And then some jurisdictions give people the choice, right, of give prosecutors the choice. If you want to bring this case forward, you can go get a grand jury indictment and then arrest the person and do it that way, or you can choose to file a complaint and information and preliminary hearing and do it that way. And prosecutors will have the choice in terms of which they want to do. And maybe various reasons why they want to do one or the other. So I'll go through that. As I said earlier, the grand jury process is far less adversarial than a preliminary hearing, right? In many places, right, defendant doesn't have the right to be present, doesn't have the right to have counsel, to present evidence, right? So those rights are significantly curtailed. So why would a prosecutor want a grand jury as opposed to an information preliminary hearing process? Because it's a lot easier to get the person brought to trial. All you need is this grand jury to return this indictment, which the prosecutor can do because they control the process. It's a little bit easier than bringing someone to trial through the information process, right, which requires a preliminary hearing, which is much more adversarial and kind of has a miniature trial. So prosecutors make strategic decisions in that regard. And also the prosecutor may want to be using the investigative function from the grand jury as well, and then decide to indict that person. So that's what I just talked about there. All right, next step, you get to the arraignment. Once, assume you are indicted by the grand jury, right? So you don't need a preliminary hearing, or you have your preliminary hearing and you're held over for court. There's an arraignment that takes place. At the arraignment, the defendant enters a plea of guilty or not guilty, and then the case usually moves forward to trial. Then we get to the pretrial motion stage. So defendants have a right to file pretrial motions, and there are many different types of pretrial motions. So some of them are very, just sort of technical, right? So under the rules of criminal procedure, for example, the defendant can file a motion requesting a copy of the preliminary hearing transcript, right? But other times the motions are really based on constitutional rights. And so the defendant can say, for example, I feel like this is the very frequently litigated motion, is a motion to suppress evidence. The defendant can say, the way that the police gathered the evidence was gathered in violation of my right against self-incrimination because I was coerced into giving a confession by the police. Or they could say, I think the search and seizure violated my right to privacy under the Fourth Amendment. And so they can bring that motion. And if they win, the evidence will be suppressed. And that might mean the case can go forward to trial without the evidence, or the evidence could be so important the whole case gets thrown out. Someone's charged with illegal possession of drugs and the drugs get suppressed because the search violated the defendant's Fourth Amendment rights. Usually the case gets thrown out because there's really no way for the prosecution to get someone convicted of possession of drugs if there's no evidence that they possessed the drugs allowed to be admitted at the trial. Address that right there. All right. We sort of move forward to the plea bargaining stage. I listed it at step 4, but the reality of it is plea bargaining occurs at every stage, can occur at every single stage in the criminal justice process, right? So it can occur from the moment you are charged with a crime, right? People enter plea bargains after the trial has started. So it occurs sort of throughout the process. You really can't emphasize plea bargaining enough. In the American system of criminal justice, it's something like, well over, so 97% of federal convictions and 94% of state convictions, right, are the result of guilty pleas. So it's for this reason, right, there's sort of a famous statement about the American system of criminal justice, right, that plea bargaining isn't just an adjunct or a part of the system of criminal justice. It is the criminal justice system itself. All right. So now we've sort of talked about plea bargaining. Now we're going to get ready for trial, right? We've done our pretrial motions. You can plea at any part in the process. So now we start to prepare for the adjudication, prepare for the trial. And in the United States, there are certain rights that defendants have to discovery. We call it discovery is information in the prosecution's possession, the reports that the prosecution has in the case, evidence that the prosecution has in the case, right? Basically what's in the prosecution's files. So this one case said, look, defendants have no general constitutional right to pretrial discovery, right? Should probably say general constitutional right to pretrial discovery there, right? So the prosecution has it. You can't say, well, they have a police report, I want it, right? Just because they have it. And that's a constitutional right. Some jurisdictions treat that differently, but you don't have that right under the United States Constitution. However, prior to trial, the government must disclose what we call Brady material, right? So that is the government must disclose to the defense counsel any evidence in his possession that is both favorable and material to either the defendant's guilt or punishment. So favorable is, evidence that would tend to make the defendant look innocent, right, or reduce the credibility of prosecution witnesses. And material is not just evidence that falls into that category, but evidence that would also have a reasonable probability of impacting the outcome of the proceeding, right? So not only is this favorable, but if I give it to you, it's going to maybe make the jury less inclined, a reasonable probability the jury would be less inclined to find you guilty. And it applies it at sentencing as well, right? Or make the judge less inclined to give you a particular sentence. And I said prior to trial, that's, just shorthand. Really, the Supreme Court has not said that there's a defined time frame in which you have to get that information, but you have to get it in enough time to be able to make effective use of it at trial itself. Now we get to the trial. All right. So in the United States, you can be found guilty, not guilty, right? Or if the jury fails to reach a verdict, it's oftentimes, right, referred to as a hung jury, right? So the jury can't make up its mind. So if the jury cannot reach a verdict, the prosecution can seek to have the defendant tried again, right? And the defendant is acquitted at trial because the defendant has a right against double jeopardy. The prosecution can't attempt to re-prosecute you for the same crime, right? And the prosecution can't appeal. That's another important part of it, right? The prosecution can't say, after the jury comes back not guilty, we think that the jury got it wrong and can appeal, right? Once the jury comes back not guilty, it's completely over. And obviously, if you get found guilty, we move on to the sentencing, right? And I think I have it in another slide here. But in order to find the defendant guilty, the jury has to be considered a unanimous jury. That's sort of a more recent Supreme Court decision. Here it is. We'll get to that in just a second. All right. So at trial, right, the defendant has a right to a jury trial, but it's not in every single criminal case. The defendant has a right to a jury trial when they're charged with a crime that carries a potential sentence of more than 6 months. So under the Sixth Amendment, you have a right to a jury trial. It's more than 6 months. And it's not just any jury. We just don't go get 12 people and we don't care who they are, right? That jury has to be impartial, right? So basically a fair jury, right? So you can't go get a jury of 12 people who absolutely hate you. And defendants have a right to waive. I shouldn't say they have a right. That's not right. Defendants can sometimes, and do for different strategic reasons, attempt to waive a jury trial and be tried by a judge sitting alone on the bench. But don't know who that is. That's a problem. Sorry about that. Right. But the prosecution has to agree to that for different reasons. So the prosecution has to agree to allow the defendant to have a bench trial. It depends where you are. Certain jurisdictions give the prosecution that right. Certain jurisdictions might not. But it's perfectly constitutional. It doesn't violate the defendant's constitutional rights to give the prosecution the right to consent to the defendant being tried by a judge and not a jury. Most juries consist of 12 persons. That's usually the case. That's certainly the case for felony trials, but it's not constitutionally mandated. For many misdemeanor cases, right, which are those less serious cases, you can have juries of at least 6 people. You can't have any juries that are fewer than 6 people. The reason is the court said if you can only get 5 people to agree that you're guilty, there's some statistics that show that only 5 people agreeing to something is much less accurate, right, than having 6 people. So you need at least 6 people on a jury. And as I said, the jury has to be unanimous. The prosecution has to prove every single element of the crime beyond a reasonable doubt, right? This is the reasonable doubt standard is a really important component in the American system of criminal justice. We'll talk about it in just a moment. The defendant gives the right to counsel to any time the defendant is charged with a felony or any misdemeanor offense in which the defendant is actually incarcerated. So basically, the judge has to decide before you're tried with a misdemeanor offense if they want to be able to put you in jail. And if they want to be able to put you in jail, they better give you a lawyer. And if they don't want to put you in jail or they're not sure and they don't give you a lawyer, they can never put you in jail. In most jurisdictions, when you're charged with a misdemeanor, you just automatically get a lawyer and the judge doesn't have to make that decision. It's just how it occurs by law. But that is technically what would happen in based on the way that the constitutional right would work. The defendant has a right to present their own evidence, right? And the defendant has a right to confront the witnesses, right? So there's a preference in the United States. It's not universal, but there's a preference for face-to-face confrontation. What that means is the witness is to come into court. They have to look the jury in the eye. The defendant gets a chance to look the witness in the eye, and they get to cross-examine them, right? And try and draw out evidence that they think would be favorable to them. And there is a right against self-incrimination. So in the United States, you can't force a defendant to take the stand and to testify against themselves, right, to plead their innocence. The government has to prove every element of the crime beyond a reasonable doubt, and they have to do it without forcing the defendant to take the stand. Right, so that's an important part of this. And if the defendant does not take the stand, the jury is told that they cannot draw a negative inference based upon the defendant's refusal to take the stand, right? They can't assume that the defendant is guilty because the defendant won't bother to defend themselves, right? All right, we're moving right along here. Just wanted to stress this a little bit. Some of you may be thinking, what is reasonable doubt? And reasonable doubt is an important part of the American system of criminal justice. So this is a jury instruction. Jurors get read this in the state of Massachusetts, and just give you a brief overview of this. And I think this kind of gives you a good sense of reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to a moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. So that's what the judge tells the jury before the jury considers the case. All right, we'll move forward to sentencing before we conclude. So now let's assume the defendant has been sentenced, right? The sentence in the United States is almost always imposed by the judge who presided over the trial, with the exception of death penalty cases, in which in many states it is imposed by a jury. When deciding the sentence the judge will impose, judges, right, are given really broad discretion in imposing the sentence that they think is fair. And judges take many different things into account, and so sometimes the legislature tells judges what to think about. So judges can think about imposing a sentence that is really harsh because the defendant has done something that offends society and they want that person to be punished, right? Judges can also impose a really harsh sentence because they believe that if they don't put this person in jail for a very long time, they're going to come out and they're going to commit crimes all over again, right? So that there's that deterrent aspect to it as well. Judges can impose harsh sentences because they want other people to see that out there in the world and say, I'm not going to commit this crime. I don't feel like going to jail for a long time as well. That's also another form of deterrence. But then sometimes judges can structure sentences in ways that they think best rehabilitate the offender, right? So a judge can say, look, I don't think that sending you to jail for a long time is a problem here. I think is the right thing to do here. I think you have a problem with drugs. I think you committed this offense because of drugs, but you're not a bad person. So I'm not going to send you to jail, but I'm going to require that you get drug treatment, right? And getting drug treatment is going to help protect the community. It's going to help rehabilitate you. And I think that that's the fair thing to do here, right? One time I heard a lawyer say to a judge that, they should give the defendant drug treatment, try and rehabilitate the defendant because the defendant was more sick than they were sinister. And I thought that was a good way to put it. Because judges have a tremendous amount of discretion in the American system of criminal justice, there have been problems that have resulted from this, right? So you could be in one courtroom and commit one offense and the judge gives you 20 years. And then the next courtroom, it's like almost the same case. And the judge gives you a fine of $500, right? It can just be like kind of all over the place. I mean, there are statutes that tell judges, for this offense, you can only get 10 years in jail or 20 years in jail. But within that, right, the judges have broad discretion to not send you to jail at all, to fine you, to send you to jail for a long time. So there was just a huge, disparity in sentencing that might take place within the same courthouse. And then there were also factors that policymakers were concerned about, that maybe judges were imposing harsher sentences on people, right, on the basis of race, for example, right? So maybe white defendants were getting lesser sentences than black sentences for the same crime. So not in every jurisdiction, but some jurisdictions have created guidelines, and these guidelines are designed to ameliorate this problem by telling the judges, look, take this guideline system, add up the person's previous offenses, right? Do some calculation to figure out, right, how bad they were in the past. Then we'll look at the current crime and we'll decide how bad the current crime is. And then within these guidelines, we're going to give you a range. And you should sentence within this range, right? If you don't sentence within this range, it's going to be a real problem. So this is kind of an example of what sort of some guidelines look like, right? Over here, right, what we have is the level here, level 1, level 2, right, level 3, right, and what we call the offense gravity score, actually. So this offense gravity score is a reflection, right, of how serious the current offense is. And then these numbers up at the cross here, right, these numbers are all an indication of how bad the defendant has been previously. So each one of their prior convictions gets a certain point total. And then right here, right, they're telling judges, look, this guy is an offense gravity score of a 7 and a prior record score of a 2. You have some discretion here, but give this guy 10 to 18 months, right? We think that that's a fair sentence, right? So that way one judge isn't giving the guy 20 years and one judge is giving the guy, 5 weeks. Defendants do have certain constitutional rights at sentencing. They have a right to be free from cruel and unusual punishment, right? Which is, you can't be sentenced to things that are preposterous sentences, and there's ways in which courts make that determination, but there are some restrictions, right, on what's cruel and unusual punishment. There's a right against self-incrimination that applies at sentencing. So, once you get sentenced, the court can't make you start saying a bunch of things that make yourself look guilty. You do have the right to a lawyer at the sentence, and that lawyer has to be effective. And I will say this, throughout the process, there's also not just a right to have a lawyer with you. Whenever you have a right to a lawyer, it's not just enough that they're alive, right? There are standards put in place to make sure that they do, demonstrate a minimal degree of competency. And this is just another part of sentencing, which we won't get overly into. But there's certain rules that govern what happens in sentencing. If these guidelines tell judges you have to give someone a minimum sentence, right, or the maximum sentence would increase based on certain factors, those have to be found beyond a reasonable doubt by the jury. And I'll go through this briefly, and we'll take some questions. Post-conviction relief: after you are convicted in the United States system of criminal justice, you are given a right to appeal. The United States system of criminal justice has an extensive sort of array of appellate rights. You are given the right to direct appeal, and then a collateral attack, and we don't have to get overly into them. But the bottom line is if you take from this nothing else, then the defendant is given multiple opportunities to appeal, and the defendant has some right to counsel on some of these appeals. Not universally, but at certain stages, we don't make the defendant do it all on their own, right? They do have a right to a minimally effective lawyer. I think that's probably fair for their questions. So we'll get into the questions. I received one over email, and I'll see if there's some other out there. But I just wanted to let you know I did a little bit of research on this. So there's a question about capital punishment. So a student had asked, does the United States still use capital punishment? Which states still use it, and which, and why not? Those who put into practice, right, who maybe are executed at various psychological problems, why do they still use it? So here's what I will say to you. So here's a chart that I had found, right? So in the United States, we have the death penalty. There is a federal death penalty, but because people are, for the most part, prosecuted in individual states, states have the option of deciding if they want a violation of their own state law to be punishable by death. There's you can't make everything, right? But you can't say somebody stole a loaf of bread, so they're going to get executed, right? That would violate the cruel and unusual punishment provision. It's usually reserved, right, for incredibly serious crimes. I myself am not a total expert on the death penalty, but it's usually, I think it has to be reserved for crimes that involve a murder or death of a person. You can see from here, the states that are in the gray are states where there is no death penalty. right? So you commit a crime in New Jersey, you murder someone in New Jersey, you cannot be executed. New Jersey has no death penalty. Then there are many states across the country, right, that have a death penalty, but it's not used very often. So, for example, in Pennsylvania, which is right next to New Jersey, I think the last time the death penalty was used was in the late 90s, and even then only used because someone gave up all their appeals and decided that they no longer wanted to fight the case. I think this is correct. I don't think anyone has been executed in Pennsylvania in decades who didn't want to be executed. So there's a death penalty in Pennsylvania, very rarely used. And then in other places, the death penalty tends to be used much more frequently. So as you can see across these states in the American South, the death penalty is more prevalent and employed more often. Some of that, I guess, has to do with the regional differences in the United States. I think what's striking here is if you look from the northeastern part of the United States, New England, through most of the mid-Atlantic, right? So really from Maine, which is in the far northeastern part of the United States, through Maryland, just really the death penalty. There is no death penalty with the exception of Pennsylvania, which again hasn't used it in a long time, and New Hampshire. I don't think New Hampshire's used it since like the 60s. So really in this part of the country, there's no death penalty on a practical level. But in this part of the country, in the South, there is. So I think some of it has to do with regional differences in politics. But across the country, the death penalty is used more infrequently. Because of extensive appellate process, imposing the death penalty can be very extensive or very expensive. And I think that we're gradually sort of beginning to see less and less of the death penalty being imposed across the United States, but it is still there, and certainly kind of in different places can be fairly active. So that is what I wanted to show you guys about that, and to sort of answer that question. Let me take a look and see if there are some other questions. A lot of different questions. Okay, so someone said that there's a lot of TV shows and movies focused on American crime, right? Did they get anything wrong about the process of investigation and adjudication wrong? What are the most common mistakes or misrepresentations of how the system works? Yeah, so that's a really great question. So I'll just take one from the investigative phase. So in the investigative phase of the process, if I can do this, you guys can see me or not, right? But in the investigative phase of the process, there's these Miranda rights. So Miranda rights have sort of existed all across the world, right? And you sort of see versions of it everywhere, right? And so it's, if someone gets arrested, you have the right to remain silent. Anything you say can and will be used against you, that kind of thing, right? And in the United States, you only need to have Miranda rights when you are placed in custody and the police are seeking to interrogate you. But on police crime shows, someone's arrested and they are just immediately read Miranda rights. And so I would represent clients, and anyone who's representing clients will tell you one of the first things that you get from clients is, I was arrested, but I was never read my Miranda rights, and they think the whole case should be thrown out. And the reality of it is, right, is that that's not really how it works. Is that most of the time the police arrest you, they don't really care about asking you too many questions, so they just arrest you. So the fact that they arrested you, you're in custody, but they haven't interrogated you, so you have no right to your Miranda rights, right? I think there's this massive sort of sense of misinformation across maybe the world, and certainly across the United States, that if you don't have your Miranda rights read you as soon as you're arrested, the case gets thrown out. And that's just not true. And if I had a nickel for every time I had to explain that to a client, right, I'd be fairly wealthy. As far as the adjudicative stage, I guess what I would say is this. When you watch the way that things go on in courtrooms, I don't know. I mean, this is the adjudicative stage. I don't know if this is so much about criminal procedure, but, as a trial attorney, it's like I watch the way that these lawyers ask questions, right? And then they give these speeches, and they just get to do all of these crazy things. And, the whole thing's just ridiculous, that they would get away with that. Basically, judges wouldn't let lawyers ask questions the way that they ask questions. Judges wouldn't, the other party would object consistently. So I think, like a lot of trial lawyers, I cannot watch shows that show lawyers doing trial work, right? That's just too much for me. So I think that I don't know if it's necessarily, about the Constitution, but that is a grave misperception you see represented on TV about how actual trials work. What do you think is the most controversial or significant trial in recent American history? This is obviously my own personal opinion. It depends how you define recent, but I will say this. I think the O.J. Simpson trial, right, probably falls into that category. There are other trials that people have paid attention to. For example, there's like the Casey Anthony trial, which took place where she was accused of murdering a child in Florida, and a lot of people paid attention to that trial. But the O.J. Simpson trial, I think, occupied a really unique sort of place in American, in American history and American legal history, in large part because of the issues of race that were implicated in that trial. And I would say that, recent history, the case is still very much with us. A few years ago, there was an American TV show, right, which was a dramatization of that trial called The People versus O.J. Simpson, I think was what the name of it was. It was unbelievably popular. There's a recent documentary about it that was unbelievably popular. So if I were to say, what's one case that, while it took place right in the mid-'90s, still sort of resonates with the American people, I think more than any other case, it would probably be that one. I know you guys asked a tremendous amount of questions. Some people probably got to drop off. Maybe take one more. This is a really good one. I think, how has the lockdown and social distancing affected criminal procedure? Just a totally fascinating question, and there are going to be a million people writing articles about that, and they're probably writing those articles as we speak. I would imagine a lot of them are going to come out and get this frequently. So I guess I would focus on sort of a couple different aspects. So one, we talked about the defendant has a right to face-to confrontation, and I said that there's a preference for face-to-face confrontation. So as the trial goes forward, one of the things you're starting to see happen now, right, is witnesses say, well, I don't want to come into the courtroom, right? I want to testify through a closed circuit television. Does that violate the defendant's right to face-to-face confrontation, right? Or you've seen defendants or witnesses say, I'll testify in the courtroom, but I'm wearing a mask to protect myself. And there's a recent decision from the Puerto Rico Supreme Court that addressed whether or not wearing a mask violated the Confrontation Clause. And what the court said was that typically you can't go into court and wear a mask. That would violate the right to face-to-face confrontation. But this is a unique circumstance. So stressing that, the court said that it didn't violate the right to confrontation to wear a mask. Another issue is that some courts have now moved to hold trials remotely, but there is a right to a public trial in the United States. And so the question becomes, how do you give the defendant a public trial? And what some court systems have begun to do is they've begun, just like this lecture is, to hold a trial in a courtroom and then stream it over YouTube, right? So people can't go into the courthouse because of social distancing issues, but is the trial public if you can still access it via YouTube? And that's kind of a really interesting question. And then right, there's another part of it too about the right to a speedy trial. So defendants have a right to a speedy trial, but many courthouses were saying, we just can't give you that right now because we don't know, we can't bring people in, can't get jurors don't want to come in, we don't want to hold trials. And so there's a question about, right, is a court system's response in delaying the trials violate the defendant's right to a speedy trial? And I think as long as it's reasonable, and I think most courts will say that delays are reasonable in light of coronavirus, the defendant's right to a speedy trial is likely not going to be violated. But that's definitely an issue that's out there as well. So these things are kicking around, and whether or not these decisions will have any value once the pandemic passes, I don't know. But definitely a really controversial and really fruitful area of discussion as we move forward. So I think that about completes our time. There are a number of different questions. I want to thank you guys for answering. I don't know if there is time to continue on or people are dropping off, but I guess that is about where we were for going a little past 12 o'clock. But if people have any questions, you have my email address, and you can feel free to email me, and I'm more than happy to do a meeting over Zoom or a meeting over Skype, and to answer any questions people might happen to have in person or over email. So thank you so much for all of you for attending. And sorry I couldn't get to all the questions, but hopefully I'll have an opportunity to answer them going forward. And thank you, the American Center, for hosting me.